My name is Professor Tim McCormack. I'm Professor of International Law in the Law School at the University of Tasmania, but I am proudly a Burnie boy. This evening we gather on Blair Heka Hillaplu country, the Emu Bay Band of the Northwest Nation, and I pay my respects to the elders of the traditional owners and custodians of this land. Like so many of our Aboriginal bands around the state, we know of no descendants of the Blair Heka Hillaplu. The impact of colonial invasion and dispossession here was so profound that we don't know that any of them survived. And that represents for us a tragic loss of language, of culture, and of history in this place. Doesn't mean that we are lost forever. The Blair Heka Hillaplu live on through the spirits of their old people that imbue this part of Tassie that we know and love. And in acknowledging them as traditional owners and custodians of this land, I pay my respects for the care and the love and the nurturing of this place that I know, and you also do, is a very special part of our heart-shaped island. Tonight we're focusing on a life in the law, a very rich one, long and fulfilled. But I, in acknowledging the traditional owners, don't want to communicate that law in this place only was administered for the 200 years that the Supreme Court of Tasmania has just celebrated. Blair Heka Hillaplu, like so many others of our Aboriginal people, they had their law, LORE, we might describe it as, but it governed their relations with each other, their resolution of disputes, the boundary markers between their sovereign land and the sovereign land of neighbouring bands and of nations. And I pay my respects to them for their honouring of their laws and customs. It's my pleasure now to introduce the Pro-Vice-Chancellor for the Cradle Coast and for Launceston, Professor Sonia Stanford, to introduce our honoured guests. Please welcome Professor Stanford.
Thank you, everyone. Thank you, Tim. On behalf of the University of Tasmania, it is my great pleasure to warmly welcome each of you to tonight's very special event. We are honoured to host this Island of Ideas conversation at our Cradle Coast campus here in Patawai, Burnie. The physical representation of our university's commitment to serving the vibrant and dynamic communities of Tasmania's diverse regions. In particular, I would like to welcome and extend my gratitude to one of the foremost judicial authorities in our country, the Honourable Justice Alan Blow AO, Chief Justice of the Supreme Court of Tasmania. Tonight we are provided with a unique opportunity to gain deep insights into the legal perspectives that shape Tasmania and beyond. Understanding these legal perspectives is more important than ever as we navigate an era of rapid change, digital transformation and uncertainty, and no one is better placed to provide this perspective than Chief Justice Blow. Chief Justice Blow's experience in the Tasmanian judicial system spans decades, and coincidentally, his connection to the northwest coast of Tasmania started early in his career. Following graduation, he practiced as a barrister in civil litigation, criminal and family law in Devonport between 1976 and 1987. He went on to practice at the bar in Hobart from 1987 and was appointed Queen's Counsel in 1995. In 2000, he was appointed a judge of the Supreme Court of Tasmania. Justice Blow was a part-time Deputy President of the Administrative Appeals Tribunal from 1993 to 2000 and has been a member of the Governing Council of the Australian Judicial Officers Association since 2000. The Chief Justice was the President of the Law Society of Tasmania and the Chairman of Trustees of the Tasmanian Museum and Art Gallery. You're getting a sense of incredible service here, I think, in this list. In 2018, Justice Blow was appointed Officer of the Order of Australia for Distinguished Service to the Judiciary and to the Law. He is a long-time lecturer in Supreme Court advocacy at the University of Tasmania Centre for Legal Studies, helping to prepare postgraduate students for legal practice. This year, the Supreme Court celebrates its 200th anniversary, and for the entire 130-year history of our law school, we have proudly enjoyed a close working relationship with the legal profession and with the court. The Chief Justice embodies the commitment of the profession to producing law graduates who are equipped to serve Tasmanian society in the pursuit of justice, equity, and the resolution of complex social and technological challenges. And Barrister Regina Weiss is one of those graduates. Now Chair of the Red Cross International Humanitarian Law Committee in Tasmania, among many other appointments, she began her legal career as Associate Chief Justice Alan Blow in 2005. In 2006, she became a federal prosecutor and then moved to The Hague to work for the Office of the Prosecutor at the International Criminal Court, the ICC. Regina spent 9 years prosecuting war crimes and crimes against humanity on cases predominantly from East Africa, including Kenya and the Democratic Republic of the Congo. Since returning to Australia, she headed up legal teams of federal government agencies in Canberra, including Sport Integrity Australia, before her call to the Tasmania Bar in 2021. Regina remains on the ICC list of counsel for victims and defence, is the ICC Bar Association focal point on sexual and gender-based violence, and chairs the ICC Bar Association Ecocide Working Group. This is a long list of things to be getting through. Locally, Regina acts for plaintiffs in institutional abuse matters, amongst other things, and is currently leading a review into former Tasmania police officer Paul Reynolds. Through the collaboration of leading thinkers and practitioners such as these two excellent speakers, our aim is to establish a platform for meaningful dialogue and exchange of ideas. We believe this can inspire positive change within our communities. It is central to our university's mission to make this platform accessible not only to our students and staff and graduates, but also to you, our extended community. And so please join me and welcome our speakers, the Honourable Chief Justice Alan Blow, AO, and Regina Weiss.
What an introduction. 19 years later, here we are. Now, before we start, today is actually a very important day in your life, Chief Justice. It's 24 years, isn't it, since you were sworn in?
On the 13th of June 2000 at about 9 a.m, yes.
How's the coincidence? So 24 years and 9 hours, perhaps. Congratulations.
Thank you.
Congratulations. Happy birthday, yes. Happy anniversary.
Thank you.
So 24 years. Now, if my calculations are correct, and look, my maths isn't brilliant, but that's an eighth of the length of the Tasmanian Supreme Court.
Pretty much, yes.
And you've been a judge for an eighth of that time.
They say there are three types of lawyers, those who can count and those who can't.
I'm not going to say which one I am. Before we start, I just want to set the scene. 19 years ago, I became your associate, and it set my career path. Without you, and I've promised I'm not going to get emotional tonight, so I'll try my best, but it set my career path. Between you and Professor Tim McCormack, I would never have done the things I would have done, and I'm grateful for that, and I'm grateful to be sitting here with you today.
Thank you.
Thank you. Now, let's start at the very beginning. I'm going to try and be chronological about this, but we'll go down rabbit holes. We've been known to do that.
Yes.
But we'll start from the beginning. Now, as a child growing up in Sydney, was it always your dream to become a judge?
No, it wasn't until I'd been in Tasmania for quite some time that it crossed my mind that I might end up as a judge. The only ambition I ever had in childhood was to be a tram conductor. And in Sydney, they took the trams away. The last tram ran when I was 11. But I didn't think much of my science teachers, and so I headed in the direction of an arts degree. And someone told my father that if I did arts law, I might actually be able to do something other than teach it to someone else. And so I ended up doing arts law, and one thing led to another.
Well, you'll be pleased to know there's trams running in Sydney again.
I've been on them.
So now
They don't have conductors.
So there you go. Well, maybe it's time to go back there. After you retire, there's hope on the horizon, perhaps. So your first job after university, or you started actually as an article clerk, didn't you?
Yeah, the arrangement in Sydney was that most people did 2 years undergraduate articles. So for my last 2 years at the law school, I was working as an article clerk and going to lectures at the beginning and end of the day, but in between doing exciting things like title searches at the Land Titles Office.
And then the opportunity came up to come to Devonport. Now, how did that arise?
I'd been admitted 2 years. I'd been doing a lot of conveyancing and probate work and was not wanting to stay in that area. My wife was pregnant and earning more than me, and something had to give. And so in those days, if you wanted a job as a lawyer in Sydney, you looked in the Sydney Morning Herald under positions vacant, men and boys. And there were jobs advertised there there were no jobs going in Sydney. There were jobs that I applied for in Goulburn, Canberra and Devonport, and I got the one in Devonport.
And then you arrived. And where was that job?
Working for a solicitor called Brian O'Rourke, who's still around, but well and truly retired. So I was there for 11 years.
And because we're in Devonport particularly, your most memorable case?
The most memorable case in those 11 years was my first murder case. I actually, my first 2 murder cases both came from the same night in Devonport, and they were completely unrelated. But the first one, which was particularly memorable, involved a man called Lee Jeffrey, who shot a man dead in the street outside the Edgewater Hotel in East Devonport. And actually, that case illustrates a number of things about practice in Devonport. I've always said that the smaller the place a lawyer goes to, the greater the degree of responsibility the lawyer will be given. And so in this particular case, I was the solicitor and junior counsel in a murder case. It also is a good example of the fused legal profession at work. In Sydney, it's a divided legal profession, has been since the early 19th century. And everybody is either a solicitor or a barrister, and they don't do each other's work. But in Lee Jeffrey's case, he was an existing client. I'd represented him when he pleaded guilty to burglary and stealing in relation to a theft from the Deloraine Golf Club. And the killing was on a Friday night. He was an experienced bushman, and he went bush, and the police were looking for him everywhere. And he phoned me at 3 o'clock on the Thursday morning, wanting to give himself up, from the phone box that then existed at a place called Claude Road, on the road from Sheffield to Cradle Mountain. And I was in that case from the time I literally went out into the bush and picked up my client and drove him to the police station. And I appeared for him all the way through, from his first appearance in the Magistrates Court, in the committal proceedings before a magistrate, as junior counsel at his trial, as junior counsel in the Court of Criminal Appeal, and as a very silent junior counsel when he unsuccessfully applied for special leave to appeal to the High Court. So that was quite an expedition.
You certainly become an expert in the small jurisdictions, that's for sure. What about in your civil practice in Devonport? Was there anything that jumps to mind?
Not a lot. I did a lot of family law in those days. The Family Law Act came in on the 4th of January 1976, and I arrived in Devonport at the end of March and was actually appearing in the family court before I got admitted as a Tasmanian practitioner. In those days, folk from interstate had to get admitted in their new state, and so family law became more than half of my practice by the time I left Devonport.
Interesting times, but then, look, I remember my decision to go to the bar, and it involved you. I remember asking you, I was living in Canberra, and I thought the bar was such a clever place for clever people to go. And in one sentence, you told me that, well, I could do it. And you gave me the confidence to go to the bar, and I'm grateful for that because the rest is history. But I'd like to hear your story.
Well, I think it's probably easier now than it was then. There were very few lawyers practicing solely as barristers in Hobart at that time. In fact, it was only about 1983 that Peter Cranswick QC, as he then was, established Treasury Chambers, and we had more than one barrister in one place. So Tasmania has a fused legal profession, and it's always been the most fused profession in the country, with the smallest separate bar. And there were various problems to do with the cash flow being a bit slow and a bit lumpy. So there were certainly months when the tide was out. But I got work in all sorts of areas. I was always a very general practitioner, so I did less crime in Hobart than I'd been doing in Devonport, more civil litigation, less family law. I got appointed to the AAT, the Administrative Appeals Tribunal, first as a part-time senior member in '89. So that was a big part of my work in those 13 years at the bar.
Yes, I have to say, now that I practice in civil litigation and particularly plaintiff work, I see your name everywhere. You and the usual suspects like Ken Reid keep appearing on most of our precedent cases, like Mercer, for example, which is still relevant, and that was, I understand, later on. But before we go to your time at the bench, what are your memorable cases as a barrister?
Oh, the most memorable is probably a personal injuries case called Grimsey and the Southern Regional Health Board. It concerned medical negligence. Megan Grimsey was being born when her mother was given the wrong injection. She was meant to be given pethidine for the pain. Instead, she was given something called sintometrine at too early a stage, something that was meant to be administered after the birth in order to deal with the placenta. The result was that the child from birth had the most terrible case of cerebral palsy. Now, we We ran that case mainly for the purpose of the assessment of damages. There were some issues about negligence, but the real issue was how much was this claim worth. And it was a multi-million-dollar claim, and the biggest component of it was the cost of future care, because the child needed all sorts of special equipment and full-time care from multiple carers. But it took on a significance in relation to the award of general damages for pain and suffering and loss of amenities. One of the first things I noticed when I came to work in Devonport, having done a tiny bit of personal injuries work in Sydney, was that plaintiffs were given far, far less by way of general damages in Tasmania than they were getting in New South Wales. And in Grimsey, the trial judge was Justice Chris Wright, who tended to be generous in awards of damages for personal injuries. He also liked large numbers in criminal sentencing, which sometimes didn't suit me. But anyway, he assessed general damages for this child at $300,000, which was far and away the largest award of damages under that head in Tasmania. The state appealed, and on appeal, the full court reduced that amount to $175,000. And we applied for special leave to appeal to the High Court. For those who don't know, the High Court has more work than it can deal with, therefore it filters out matters that aren't sufficiently important or meritorious. And special leave was refused, and I remember Justice Callanan asked me, but surely, buying a house in Tasmania doesn't require as much money as buying a house in Sydney, to which I said, yes, but if you go 100 miles out of Sydney, there are houses whose prices are comparable to Hobart. Well, it didn't do me any good. But you've mentioned the Mercer case. Years later, as a judge, I was, in fact, just after I became Chief Justice in 2013, I was hearing a case where I was required to assess damages for a quadriplegic. This man, well, two things had happened to warrant a departure from the niggardly awards of damages that were the norm in Tasmania. First of all, there was legislation that had come in that said that judges awarding damages could have regard to comparable awards of general damages in this state and other jurisdictions. That was brought in as part of a package of reforms that were designed to make insurance more affordable at the expense of injured plaintiffs and bereaved people. So that was there, and that entitled me to have regard to the prevailing rates of awards for general damages outside Tasmania. The second thing that warranted a different approach was that Mr. Mercer demonstrated the mobility of the Australian population. He'd grown up, like me, in the northern suburbs of Sydney. Like me, he'd moved to Devonport and worked in Devonport. Then he'd moved to the south where he established a business in Bridgewater where he was injured. And then when he became when he was injured, he had a brother in the northern suburbs of Sydney, and he decided to move back to New South Wales and actually moved to East Gosford. So why on earth should he get a Tasmanian award of damages? So in his case, I awarded 240,000, and that went through without a murmur. Times have changed.
Yes, they certainly have. And now, of course, we have ZAB and Steen and have followed suit. Actually, that prompts me to ask a question about something we spoke about today earlier, which was that surreal moment you might have when you see, when you as a judge use as precedent a case where you've argued it as a barrister. In a small jurisdiction like Tasmania, you argue a point, you get up on it, and you create precedent. And then you, sitting on the bench as a judge, rely on that precedent.
This question is a Dorothy Dixer. When the murder case from 1980 went to the Court of Criminal Appeal, Lee Jeffries' case, one of the things that I tried to argue was that because we ran an insanity defence unsuccessfully, and I tried to argue on appeal that the judge should have directed the jury that psychopathy was a mental disease for the purposes of our criminal code provisions as to insanity. Now, with hindsight, I can say that was just plain wrong, and the three judges of the Court of Criminal Appeal each said that that was just plain wrong. A couple of years ago, I was doing a judge-alone trial. We now have them, but not many of them. And the question arose whether the defendant's epilepsy was a mental disease. Was that a question of law for the judge? Queensland cases suggested that it was. Or was it a question of fact, which would have been a question for the jury if there was one? Was it a question of fact? Well, 41 years previously, the Court of Criminal Appeal had rejected my argument in relation to psychopathy, and so I followed that precedent in an epilepsy case in 2023.
There you go. What goes around comes around, doesn't it?
I told you it was a Dorothy Dixon.
Yeah, the one and only. I won't do any more of those. I'll catch you by surprise now. So you went to Malthouse, is that right?
Malthouse Chambers, yes. There were 5 of us in chambers in a building that was already named Treasury Chambers. It had been just across from the Treasury buildings, across Davey Street. It had been given that name by a wine merchant who operated there. And for a while we were in Treasury Chambers. In 1991, we bought a former malt house in Hampden Road, Battery Point, up above the Supreme Court. And several of us moved there and called it Malthouse Chambers.
Well, I won't ask you for any dirt on your fellow barristers because I already know that myself. So then you became a judge. So how did that come about? How did you throw your hat in the ring for that one?
Prior to 2000, the government quietly got in touch with prospective judges, and they were tapped on the shoulder and asked whether they would like to be appointed. In 2000, times had changed, and there was an advertisement in a newspaper advertising for expressions of interest. And so for the first time since I responded to that job ad in the Sydney Morning Herald under positions vacant, men and boys. I sent in an expression of interest addressing selection criteria and saying nice things about myself, which was something I was not used to doing. And well, they must have liked it because I got the job.
24 years ago today, sworn in.
That's it,
That's
yes.
it. And the rest is history. Then I joined you in 2005. Memorable moment, I'm sure, as associate number 6.
That's it.
Yeah, I'm not going to ask you to speak about me, but I do remember our interview, and I'd given you my CV, or resume, as we called them, and you noted that my references were the now dearly departed Terry Fools and Judge Stephen Escourt. And then you also noted that I worked at Barcelona, which is, I think, now another bar. It was all bar one then. And you asked me whether those people were my customers. And I said yes, because that was exactly right.
Yes.
And then I became your associate. Now, one of the first things I noticed when I joined you as an associate was a whole bunch of lever arch files that had Orange Ruffy written on them. Now, can you tell us about that case?
It's the longest and most difficult case I've ever had anything to do with. It was a Commonwealth fisheries prosecution with 5 accused, and the plan was for it to be a jury trial. But after about 6 months of court time, they did a deal, and the charge was watered down and they pleaded guilty. But we went through 6 months of the sorts of things that the judges do before a jury gets empanelled. There were arguments about subpoenas and particulars and whether the charge was a proper charge, and about the validity of search warrants and what is a fishery anyway, and the regulations under the Commonwealth fisheries legislation. At one stage, I was given the most unreliable time estimate that I've ever been given. There had to be an argument about whether certain evidence was unfairly obtained. The leading case was Bunning and Cross. And I said to the 5 silks appearing for the 5 accused, how long is the Bunning and Cross argument going to take? And these 5 silks, 3 from Adelaide, 1 from Melbourne, 1 from Hobart, one by one said, 2 days, Your Honour. Yes, 2 days, Your Honour. Ken Reid, whom you've mentioned, was number 2 on the prosecution team of 5 barristers, and his leader was absent. So I said, Mr. Reid, how long do you think it's going to take? He said, we don't know, Your Honour, but it will be longer than 2 days. 9 weeks. 9 weeks. One of the prosecutors had to go into the witness box, and she was there for a week. When it got to the time for counsel to make submissions, Lindy Powell QC from Adelaide stood up at 10 o'clock on a Monday morning and spoke till lunchtime on the Friday.
Now, can you tell me, have you eaten Orange Ruffy since?
I have, but very cautiously.
Now, in addition to the cases we've spoken about, is there any other cases which you think have been very important, in your last 24 years on the bench that have had the most impact?
Most of what we do is very routine work. I was the trial judge in the Neil Fraser case, therefore I'm not going to talk about it. But apart from that, probably the most important case that we've done was a case called Shaw, and it won't be of any significance to anyone other than criminal lawyers, but we sat, the Court of Criminal Appeal sat with a bench of 5 judges for the only time this century. It concerned the directions to be given to a jury about a joint criminal enterprise. What if a number of people plan to commit a crime and one of them is present when the crime is committed but doesn't actually do anything? On what is that person guilty, and if so, on what basis? Now, there was a Queensland case that said, yes, that person qualifies as somebody who actually commits the crime. Work that one out. There was a Western Australian case that said, no, that's not right. And there'd been a lot of cases where different judges had expressed their views one way or the other. And the question also arose as to how a person in this situation fitted into Section 4 of our criminal code, which concerns common purpose. And there were conflicting decisions of the Supreme Court of Canada and the Supreme Court of New Zealand as to that. And nothing right on point in Australia at all, even though we've had a criminal code since 1924 and Queensland's had one since 1899. Well, we followed the Western Australian case, not the Queensland one in relation to the first point. We followed we followed New Zealand and not Canada in relation to the second point. And about 2 months later, the identical point came up in the High Court, and nobody noticed that we'd given this judgment, that we'd all put a lot of work into. You know, I'd found the second reading speech for the introduction of the Criminal Code, which was published in the Mercury in 1924, 50 years before our Parliament had Hansard. We'd looked at comparable cases in places like Manitoba, and the High Court, 3 judges of the High Court in one paragraph said what we'd been saying without all the hard work. So that I see as the most important case I've been involved in. But it's a couple of narrow points that are really only applicable in criminal law cases involving people getting together to plan crimes.
It's a very important point, and the important point is we did it first in Tassie. Now, one of my very proudest moments in our friendship and our 19-year friendship, Judge, was when I was invited, when I was living in Canberra, when I was invited to come along and watch you receive your Officer of the Order of Australia medal along with Margaret and Katrina. And that was for your services, obviously, to the law and as a Chief Justice, and also to legal practice, which I'll get to in a minute. But there is another medal you received previously to that in 1996, and that was an Order of Australia medal for your services to the arts. Now, I know we've been talking about the law, but let's take a little interlude and talk about your service to the arts, because we're very proud of our arts in Tasmania, and it was before David Walsh and Kirsha, forged forward in Mona. So you maybe set the path for that?
No, I didn't do the sort of things they do. I was the chairman of trustees of TMAG, the Tasmanian Museum and Art Gallery, from early 1991 to March 1997. And I was also on the board of the Salamanca Arts Centre from 1988. I I got the OAM in 1996. They were my main contributions. A lot of what I did involved chairing meetings that accepted recommendations, but I did have a lot of input into what TMAG was doing.
Well, we're very grateful for you for doing that in those early days. Now, and one of the reasons you got your a medal in 2018 was for your contribution to legal education and professional standards. Now, your entire career, you've given very, very generously of your time to the legal practice course. I have to say, when I was going through that myself in 2005, I was very surprised that within weeks you were appearing before Supreme Court judges who would take the time after hours, after a long day in court, to help you with your advocacy skills. And one thing I've learned, and I've practiced all over the world, and from here to The Hague, people are astounded that judges of a Supreme Court, of the highest court in the territory or location, would give their time as generously as the judges do. And you have not faltered from it. So first and foremost, thank you for doing that for all of us and for doing that for you, Taz. We are so grateful for that. But more importantly, what's kept you going in that role?
Oh, well, it's very important, and it's an opportunity to give back. But look, I'm not Robinson Crusoe. There are dozens of lawyers, magistrates, judges, and tribunal members who do voluntary work as instructors in the Tasmanian legal practice course, far more so than in the equivalent courses on the mainland. It's probably a lot easier to do it in a small place. The course is based over at the art school on the other side of Sullivan's Cove from where the court is in Salamanca Place. It's a bit different in Sydney, where the College of Law is at St Leonard's, which is a 15-minute train ride from the CBD. But the culture of the legal profession in Hobart involves lots of practitioners giving their time to help educate the students or trainees at the legal practice course, which most of them went through. The course has been going, I think, for a little over 50 years, and it's something that Tasmania can really be proud of.
Hear, hear. I completely agree. It's really taught me the importance of paying it forward as well, and being a mentor and taking care of young practitioners coming through. I certainly like to follow your example in those situations, that investing your time and energy into young practitioners coming through means that we in turn have a great legal profession here. So it benefits for all of us. So thank you for that example, which I've tried to follow. Now, when I asked you about what else we should talk about today, you said we should talk about the jury system.
Yes. Yeah. All right. Well, I'll start with an anecdote and then I'll be serious again. The judge that I replaced was Justice Chris Wright, whom I mentioned earlier. He made a speech on his retirement in March 2000, in which he said that he thought the jury system should be abolished. He thought the juries got it wrong about one time in four, and he thought that they did things much better in Scandinavia, where the courts would consist of a a lawyer who acted as the sort of chair of the proceedings, and 2 lay people, so 2 full-time lay judges. The Tasmanian Bar Association had a newfangled thing called a website, and it published a report of this speech on its website under the headline, "Judge Resigns, Tells of Attraction to Scandinavian Model." Now, I said I was going to be serious. Just think about how the newspapers deal with judges when they don't like their sentences. We're pretty lucky in Tasmania. The Tasmanian newspapers aren't as vicious as some of the ones on the mainland. Imagine what would happen if verdicts of judges were routinely attacked by newspapers who thought that people who had been acquitted should have been convicted. It would really reduce the public's respect for our system of justice. We do have judge-alone trials as an option. They haven't been here in Tasmania for long, and there have been very few of them. But if we didn't have juries with members of the public selected at random, taking responsibility for the verdicts in relation to other members of the public, I can see that we would very rapidly have newspapers suggesting that judges were out of touch with reality and suggesting that our decisions were not to be respected. Another important point is that from time to time you get authoritarian governments that enact laws that are quite unfair, and a jury system can be an impediment to authoritarian or totalitarian rule. After the rebellion at the Eureka Stockade in 1854, a number of men got charged with treason and would have been hanged if they'd been found guilty. None of them were found guilty. When there was a mandatory 5 years imprisonment for Indonesian deckhands on people smuggling boats, something like 2/3 of the people who faced those charges were acquitted by mainland juries. So that's another important point about the value of a jury system. So that's my view. I wouldn't go for the Scandinavian model.
One would hope not. Now, thank you so much for this time that we've spent, you and I. We're going to open it up now.
And before I open it up to questions, I just want to say a couple of things. That was brilliant, you two. And thanks so much. I mean, hilarious, actually, as well as serious. But you obviously, very comfortable with each other. We knew that. That's why we asked you to be in conversation. But I think it's also incredible, Your Honour, that you can remember the facts and the details like that. Those cases, those anecdotes, they just all come out. It's magnificent, isn't it? Thanks very much for being prepared to come and share with us.
Oh, thank you.
It is time for Q&A. We've got some online questions. They're just lining up. I want to start with one online because it's an absolute cracker. Comes from a couple of blokes in South Hobart, and it says, "Hey, Mum, can you please ask the Chief..." I'm kid you not, I'm reading this. Can you please ask the Chief Justice what subjects do we need to focus on if we want to be good lawyers? Your sons, Henry and Eddie. All of 9 and 7? Yeah, 9 and 7-year-olds up in South Hobart. Here's the question. You got to ask that of the Chief.
Go to bed, boy. Oh, no, it's only to 7. Thank you, Damien. what do they need to focus on? Because at the moment, you know, it's not happening.
Well, not science, obviously, but no, I'd suggest history and English.
I think at least my youngest Eddie would prefer to be a tram driver or conductor.
Okay, another perhaps more serious question from online before I open it up to the floor. Does the legal system here have a different outlook on precedents from the mainland or from the United Kingdom?
No, that's the simple answer. The long answer is that we have to follow the decisions of mainland courts unless we believe them to be plainly wrong. So if we think they're wrong but not plainly wrong, we have to follow them. Well, I'll give you an example. I had a case involving a tragic accident where a man who'd been drinking in a pub in Triabunna rode his wife's motorcycle heading home to Orford, and because he'd had so much to drink, he crashed into the bridge over the river at Orford and was killed. He'd actually, before he'd had too much to drink, got the publican to put the motorbike in the beer storeroom and the keys in the till. But when he'd had a few more drinks, he insisted that the publican give back the bike and the keys, and off he went to his death. Now, the widow sued the management of the hotel, saying that the publican had a duty of care requiring him to not to have given back the bike and the keys. So, and that case eventually went to the High Court, but there'd been a similar case where a woman in Tweed Heads had gone to a so-called champagne breakfast where she had far too much spumante. The manager offered to get her a cab. She swore at him, went outside, tried to walk along the Pacific Highway, stepped onto the roadway, and I think she was killed. And when that went to the New South Wales Court of Appeal, they said 3-0, there was no duty of care. When it went to the High Court, 2 judges said there was a duty of care, 2 judges said there wasn't a duty of care, 2 judges said it was unnecessary to decide because if there'd been a duty of care, the manager had discharged it by offering to get her a cab. So what was I to do? I followed the New South Wales Court of Appeal. I had to. Their decision hadn't been overturned. And my decision was reversed by our full court and reinstated by the High Court.
Yeah. Excellent answer. Thanks very much. Are there any questions from the floor? Yes, second row.
Justice, I want to ask a broad question about what society, what governments, and particularly what lawyers should do in cases where there's been an injustice, but for whatever reason, particularly by the failure of counsel, it is not accepted. There was a Tasmanian case, not terribly well known, in 2021 called JAGD, where a man from the Huon was charged with a sexual crime, rape, I believe, and he'd been basically driving a woman home in his car that evening. The car hit a little bridge, causing a small amount of damage. I don't believe it was major. They then drove to some residence where she alleged that he raped her. He was duly convicted. His appeal was overturned on conviction because of the incompetence of his lawyer, because he hadn't raised the point that her first communication with the accused after that evening was a few days later when she sent him a text message asking about the damage to the vehicle, but it said nothing about the alleged rape. And the failure, the incompetence of his lawyer in not raising that was held to be sufficient to overturn the conviction. That was a Tasmanian case of 2021. It didn't get much publicity, won a year later in Victoria. The point is, if there is considerable evidence of gross incompetence by the Defence Counsel, and the so-called great appeal lawyers that come over here from the mainland fail to raise the most basic points that reading the transcript would show them, such as that there was a letter in this case in the defence position
that's enough
that
detail.
showed that this woman was living at
Let's
Mara
have
House
the
in
question.
Salisbury.
If in the circumstances
So
where
what should society, the governments and the public do in a case like that where there's ample evidence of something like that, but it's been missed by the appeal lawyers because of their incompetence? Should they just forget about it, or should the governments be more amenable to having inquiries into the matter?
Well, I'm not going to comment on Neil Fraser. You've been in the law longer than I have, and you should know why I won't. One of the things that can be done now is that if there is fresh evidence, there can be a second appeal. The other alternatives are to have what happened in New South Wales, where there's some sort of inquiry or royal commission, if it's warranted, where the example you gave is of the woman who was convicted of murdering her children was found not to be guilty on the basis of new medical evidence. Look, juries get it right most of the time. Counsel are competent nearly all of the time. I think we have minimal numbers of cases of injustice, and governments can establish royal commissions and the like when they need to. That's my answer.
There's an online question from an anonymous attendee to you, Chief Justice. I understand that lawyers, solicitors, barristers are increasingly using artificial intelligence in their practice. Is that correct? And if yes, is the use regulated in some way? And what do you predict to be the impact on the profession of increasing use of AI?
It's just starting. Yes, of course, the use of it is increasing because we've started from zero. Some judges and barristers will use AI to do a first draft of a judgment or of a submission. There are traps. AI can hallucinate. AI can give you the names and references of a whole lot of relevant cases, but every now and again it will make up the sort of name and the sort of reference that it thinks ought to be there. I've read reports of a lawyer in the USA being caught out not having checked what ChatGPT had written, and of an unrepresented litigant in Perth who fell into the same trap. But it's here to stay. Courts in other jurisdictions have published guidelines in relation to the use of AI. Certainly, Victoria, Queensland, and New Zealand have all got published policies to guide the legal profession. We haven't yet, but that will certainly come one day. Some of the larger firms have got their own bespoke AI programs for the discovery of documents. So if you're in a big commercial dispute, for example, with particular firms acting for you, AI will generate the list of documents that have to be disclosed to the other side. And I've heard at a conference that if you want your document not to be included in the list, it pays to have the words footy tipping in big capitals somewhere in the document.
Yes, please, on the third row.
Retired teacher and short-term member of the House of Assembly, taxi driver, real estate agent and many other jobs. I think I've got a pretty good judgment of a cross-section of the Tasmanian community. And I've never been aware of a teacher over my 38 years career here ever having been called up for jury service. And I was very active in the Teachers Union, having 4 years as president, socially mixing with teachers and so on. And I'd just be interested, sir, to know whether you had ever in your career had serious doubts about the juries in trials that you were conducting had really represented a balanced cross-section on average throughout your career as a judge, or whether it was skewed in one direction, socially, intellectually, or another direction, or whether it was a happy balance in your experience.
Thank you. Thanks for the question.
I think it's a happy balance. I once had an all-male jury in a sexual case, which I found a bit surprising, but there was nothing I could do about that. There is a bit of a concern in that people with responsible jobs tend to be able to get out of jury service, whereas people with no jobs or insignificant jobs tend not to be able to get out of it. So there is a bit of a worry that the people who would make the best jurors sometimes aren't there. But I don't see that reflected in the verdicts. I get very little information about the jurors. I get the year of birth and the name of the town or suburb where they live, and I can see what they look like. Years ago, we used to get their occupations, but of course that came from the electoral roll, and when they went onto the electoral roll, they were all students. So about 40% of the jurors seemed to be students, according to the jury lists back in those days. No, I don't see a problem. I can't tell you whether we've had teachers or not. Actually, I do remember on one occasion my associate said that her maths teacher was on the jury. There was a witness who couldn't do arithmetic.
Another question from online again, an anonymous attendee. What will you miss most after leaving the bench, Chief Justice, and what comes next for you?
What comes next? My wife has had a discussion with the Chief Justice of the Northern Territory, and next year in the dry season I'll be doing 2 months as an acting judge in Darwin, or I hope to. What will I miss most? Probably the intellectual challenge from all of it, and probably being surrounded by people with large numbers of people with similar interests. So the social and the intellectual benefits of the job. I won't miss the unremitting hard work.
Anyone else from the physical audience? There's a stack of questions here online, so I'm happy to keep going with them, but just don't want anyone to feel like they didn't have an opportunity. Okay, from another anonymous attendee, with respect to the media hype you mentioned, I would still be interested to hear your perspective on why you think Tasmanian sentences seem to be fairly lenient for serious criminals. For instance, does sentencing take things like the full capacity of the prisons into consideration, or is it only about the case and the perpetrator in that particular situation?
All right, we don't take into account the crowding of the prisons, although if overcrowding in the prison was a real worry, that would be a very minor consideration. I think Tasmania is a low sentencing state compared to some other states. There's no right or wrong about whether low sentences, short sentences or long sentences are more appropriate. One of the things that all the academic research shows is that the increasing sentences doesn't deter people from committing crimes. So if a government decides to get tough on crime and increase penalties, that's not going to result in fewer crimes being committed. We didn't talk about the jury sentencing study, but before she became the governor, Kate Warner led some research into what jurors thought of our sentences. And so after jurors had sat through a case and they were asked what they thought an appropriate sentence would be, then they were told what sentence the judge had handed out. Generally speaking, the judge's sentence was a tiny bit more lenient than the average juror sentence. And they were asked what they thought of the judge's sentence, and 90-something% thought that it was either appropriate or very appropriate. So the public seem to think that our sentences are all right, but there are some areas where they're less of that view than others. I think for sexual crimes, they tended not to be so approving as they were for other crimes.
I'm just going to jump the gun here. I know I've asked enough questions, but what are your thoughts on civil jury trials? We've just had a really big award in Victoria for a sexual abuse matter, which has gone to appeal, but it was over $5 million, and a big portion of that was generals, and you know the understanding is that general damages particularly are for a reflection of what the community thinks. So if the community's awarding bigger and bigger general damages, what are your thoughts on us becoming a bit more like America and having jury trials here for civil matters?
Well, they're available in some civil matters, not for road accidents, not for work accidents. I've seen very few. I was in 3 as counsel. I've done 1 as a judge. I think juries are ill-equipped to do the sort of work necessary in a big trial. If you read the judgments that judges hand down in big personal injury cases, they go on for pages and pages and pages, and they involve all sorts of very detailed considerations. And gone are the days when jury trials in civil cases were simple things. So I would be very reluctant to entrust to a jury a really complex civil trial if I were a litigant or counsel making a decision. Having said that, though, there are times when if you're a plaintiff or a defendant, you might think you're more likely to get a good result from a jury than you would be from a judge, just depending on the nature of the issues.
Well, there's a classic question online which to me represents everything you wanted to ask the Chief Justice, but never had an opportunity to do that. Listen to this. The Mercury reported during COVID-19 that his Chief Justice had to be excused from a hearing for 5 minutes, which he was hearing from his home office, because someone was at the door with a parcel. The question is, what was in the parcel? That is from an anonymous attendee online. Up to you where the answer is.
It was a delivery from Woolworths. My wife was on the phone and I heard the doorbell ringing and she didn't. So I had to interrupt the hearing.
Well, I admire the willingness to ask it. Perhaps we'll just finish off with this question from Anthony online. Chief Justice, can you recall a case involving alleged medical negligence in which the injury or disability experienced by a patient was in fact an accepted risk, identified at the time of signed informed consent, and therefore damages not awarded?
No. I would have thought that if that were the situation, the case would be identified as a loser and abandoned long before trial, abandoned or settled long before trial. I can't think of such a case.
Yeah, interesting question. I'm not sure whether the person who asked it can think of such a case or not, but yes. Then perhaps just one final one, even though I just said that would be it. Chief, has the Tasmanian jurisdiction, this is from an anonymous attendee online, seen a rise in the sovereign citizen movement in the courts?
Well,
To a
yes, once
problematic
again, it used not to exist. Yeah, we do see people like that, not as much of a worry here as it is in some other jurisdictions, where in Sydney I was told of one case where dozens of people went to court when a judgment was to be handed down, and fortunately half of them went to the wrong courtroom. But we do have cases where people say that they're not liable to pay their rates or not liable to pay their land tax.
Well, I'm very sorry, but we've run out of time for more questions. Online, there are at least another 8 or 9 unasked and therefore unanswered. So to those people who took the time to write those questions, I'm really sorry that we haven't had a chance to work through all of them, but thanks heaps for the interest. Please join with me in thanking the Chief Justice and Regina for such a wonderful conversation and for taking the time out of the schedule on circuit here in Burnie to be with us tonight. We're most grateful to you both. Thank you.
Thank you all. It's been a great pleasure.